back. The gentleman from Arizona, Mr. Stanton, is recognized for 5 minutes.
Thank you very much, Madam Chair, and thank you, Mr. Olsen, for your service at the Department of Justice and for answering the committee's questions today. Throughout this Congress, this committee has made it a priority to examine the federal government's surveillance and data collection practices, and protecting the due process rights of all Americans has been paramount in our work. One particular area of concern has been the DOJ's use of non-disclosure orders, or NDOs. These court-ordered NDOs prevent technology service providers like Google, Apple, or Verizon from notifying their customers that the government has seized their personal records or emails from the provider. And during a hearing before this committee in June of last year, executives from some of our nation's largest tech companies testified that they received thousands of these NDOs from the DOJ every year. In fact, leaders from Microsoft indicated that they receive 7 to 10 of these gag orders every single day. While the use of these secrecy orders may be justifiable on national security merits, the volume and frequency with which the NDOs are utilized raises concerns about their misuse or their overuse. And the fact that journalists and members of Congress were swept up in investigations involving NDOs, potentially implicating First Amendment liberties and separation of powers, calls for additional scrutiny into these processes. In response, I joined a bipartisan group of my colleagues from this committee in introducing the NDO Fairness Act to provide more guardrails around the use of NDOs, including by raising the legal standard to a strict scrutiny analysis, establishing a 30-day limit on NDO's effectiveness, requiring notice to be given to customers 72 hours after the expiration of the NDO, and allowing providers to contest the gag orders in court. I was pleased that this much-needed oversight bill passed through the House of Representatives in June. I hope the Senate will take it up very soon. So, Mr. Olsen, I'd like to ask you some questions about 18 U.S.C. 2705B and the DOJ's use of the NDOs. Prior to this committee's examination of the issue and subsequent passage of the NDO Fairness Act, had the department considered changing 2705B policies to prevent the overuse of gag orders by DOJ prosecutors?
Mr. Congressman, I'm not aware of prior policy or consideration around the use of non-disclosure orders. If I may, I can tell you that as a former federal prosecutor, they can be, non-disclosure orders can be an appropriate and important part of a criminal investigation to preserve the integrity of the investigation. They are subject to constraints, time limits. They must be issued by a judge. They typically would only be appropriate in cases where we are seeking to protect someone's life or to protect against the destruction of evidence. I am aware that there are concerns about their overuse. I'm aware of those concerns, and because they do impose restrictions on third parties. But I do think there are constraints that apply to their use.
On May 27, 2022, Deputy Attorney General Lisa Monaco's released a memo providing a prosecutorial clarity on 270B procedures. The memo includes reminders that, quote, a protective order should be sought only after prosecutor engages in a case and fact-specific analysis, unquote, and, quote, a prosecutor must provide a court with sufficient facts to permit the court to conduct the same case and fact-specific analysis, unquote. Why do you believe DOJ prosecutors were required to have this reminder?
I'm not exactly sure what was the reason for the Deputy Attorney General's memo, but I do find the language you read to be appropriate and consistent with my experience that non-disclosure orders should be issued only based on the particular facts in a case where such an order would be justified, again, to protect against danger to a witness, for example, or against the destruction of evidence.
In June 2021, executives from tech companies and communication providers testified to this committee that there was merely a, quote, rubber stamp process, unquote, for obtaining these gag orders in court. Have DOJ prosecutors been treating 2705B requests as rubber stamp process, as the providers allege?
So again, I can't speak generally to how prosecutors around the country are using those orders. I do agree very much with the policy from the Deputy Attorney General that they should be viewed and used only on a case-by-case basis where the circumstances warrant.
Okay, lastly, Mr. Olsen, will you commit to conducting a review of the National Security Division's usage of 2705B orders?
if I may, I would like to consider how we would respond to that question and get back to you.
Okay, look forward to hearing your response soon. Thank you. I yield back.
The gentleman yields.